Welcome to the Wellness Law Podcast, where wellness and the law meet for contemplation and collaboration. This podcast is brought to you by the Center for Health and Wellness Law. I am your host, Barbara Zabala. Welcome to the Wellness Law Podcast. I'm really thrilled today to have as guests on the podcast Kit Chaskin and Lauren Galanti. They are with the company Third to First, and we're going to hear about what that means and what they do in a moment. But just a little background about the two founders. Kit was a practicing attorney. She did a lot of litigation for leading law firms like Reed Smith and started working with Third to First, I believe, in 2017 timeframe, Kit. And she's got a well-storied career of legal work, and they'll talk more about the things that they're doing now with Third to First, but she's a very renowned and impactful lawyer, and I'm so pleased that she's joining us. And then her co-founder for Third to First, Lauren Galanti, she functions as the organization's chief operations officer. She's been involved with entrepreneurship and marketing for over 20 years of her career, and now she has co-founded this organization that we're going to learn about that deals with toxic work cultures, which is great because it fits within the theme of our most recent podcast episodes. And I'm just pleased that they're here to talk to us about their work with Third to First. So welcome, Kit and Lauren.
Thanks so much for having us.
Oh, well, I'm thrilled, as I said, and that is true. We talked briefly a few weeks ago, so I got an idea of the work that you're doing. But to introduce our listeners about what it is, you guys deal with companies, you consult with companies which I suppose most companies have, employment practices liability insurance. And one of the things that you say on your website is that EPLI, that's the abbreviated term for employment practices liability insurance, pits the interest of employers against employee well-being. I'm summarizing, but that's the message at the forefront of your website. And I was hoping you could talk about, what do you mean that EPLI insurance pits the interest of employers against employee well-being?
Lauren, you want me to take that?
Sure. Yeah.
Okay. Employment practices liability insurance is a third-party liability policy. That is the same type of policy that you would have in place, a general liability policy. Say somebody slips and falls in the lobby of your headquarters. That person sues you for their injuries that they sustained from falling in your lobby. They are an adverse third party under the policy. So the same basic format fits with employment practices liability insurance. But who, in the instance of employment disputes, is the adverse third party? It's actually an employee of yours. And it's the employee who sustained the harm by being harassed or discriminated against. So the structure of an employment practices liability insurance policy really casts a survivor of workplace harassment, discrimination, assault as an adverse third party. And then has a lot of troubling ripple effects that run through HR policies and management policies and even trainings within an organization that really discourages employees from reporting instances of harassment or discrimination.
Yeah, I think this is such an important point that I suspect, because I know it was the case for me, so I'm assuming it would be the case for others, is lost on people. Yes, you have insurance as a company to protect against claims, as you said, like slip and falls and other accidents that might happen inside of your organization. But when you have a toxic work culture, harassment going on at the employer, when you ask your insurance company that offers the EPLI insurance for assistance, this is what you've identified as the problem. You're basically pitting one type of employee against another type of employee, the bullies, if you will, against the victims of the bullying. And the policy is supposed to, would presume, and I think that's what a lot of people assume, to protect everybody inside the organization. And basically, it's really only protecting the people who are creating the toxic work culture in a way.
Yeah, I
Absolutely.
mean, I always say it's not EPLI's fault. Its parents made it the way it is. The parents of EPLI are Title VII and commercial general liability policies, and both of those are set up to deal with adverse third parties. The way the courts interpreted Title VII created a really adversarial relationship between employers and employees who suffer Title VII harms. And that's just the world we live in. We live in an adversarial system. But there are alternatives to a third party liability policy, including a first party reimbursement policy, which is why our company is called Third to First. We convert a third party liability policy in these circumstances to a first party reimbursement policy so that the company can take care of survivors, hold harassers accountable, and communicate to the other employees what they just did.
Interesting. So how does that work? Like how would an employer who has a third party liability insurance policy convert it to a first? What's the process, and more importantly, what's the outcome? You guys have been doing this for a while, and correct me if I was wrong in the introduction. Has it been since 2017? I'm going on memory here.
Yeah. Yeah.
We met about the end of 2016 and we started talking about the issue. And then we spent a very long time having this as a side project that we were both very passionate about. We ended up doing a lot of R&D, talking to a lot of company leaders, corporate leaders, about the concept to assess interest, but also creating a product to fix the issue. You're asking, how does this work? Well,
Yeah.
the good news is that Kit spent a good long part of her career customizing corporate coverages. She is incredibly experienced and a genius in this area of like, how do we fix this problem systemically? And I'll let her talk more about the invention in a bit, but timeline wise, we talked to corporate leaders. We originally went directly to insurers and said, hey, we have a recommendation that you make a change to the bog standard EPL policy. It will benefit everyone. And I think at the time, Me Too hadn't exploded yet. We were a little too early with our discovery. So again, we were having these conversations as a side project. Then we won a Fast Company world changing idea recognition. So we thought, oh,
Yeah.
this is probably real. And then when the opportunity afforded us a way to do this full time, we took it. And that was only very recently. It's been, gosh, less than a year that we've been able to focus on this full time. But I will say that we are full throttle at this point, having conversations both with the insured and insurers to change both at the individual level and as a bog standard across the industry.
Great. Congratulations on the fast company recognition. I wasn't aware of that. And how does this work then? So if a company out there listening has one of these legacy EPLI policies that covers basically creates this adversarial relationship. If a claim is made that there's harassment in the workplace, the policy is going to cover the claim that for the harasser, and then the adverse third party becomes the victim of the harassment. You're trying to change that dynamic so that it's first party coverage and it's reimbursement to the victim, right? I'm getting that correct?
Yep.
Yes.
That's
So
so a
that
company
victim isn't basically ostracized in a way. So how does that work in practice?
So, a company that wants to change its insurance coverage, these policies are customizable. They're not off the shelf like your auto policy or your homeowner policy. You actually have, as a corporation, the power to work with your broker to customize your insurance policies to fit your actual risks. So that's what I did in my law practice for many years. And the way you do that is you go to your broker and you say, we would like to put this third to first endorsement on our employment practices liability policy. And what that endorsement does is it changes your policy under certain circumstances. So for the 90% of what EPLI policies cover, for example, wage and hour disputes or a million, there's just a lot of covered claims under an EPLI policy that don't fall into this bucket on employee harassment discrimination, those Title VII violations, your endorsement is triggered once somebody reports and you conduct an investigation and you find that the event did take place. So we're not talking about spurious claims or unverified allegations. We're talking about something that the company itself agrees happened. In that case, your APLI policy converts to a first party reimbursement policy, which is just like your auto policy, basically, right? You have a valuable asset of your organization, which is an employee who has been harmed by this harassment or discrimination, and the insurance covers the company's efforts to make that valuable asset whole again. But that would include counseling, moving that person to a different team or a different facility, various, you know better than us, Barbara, various wellness things that cost money. And there's a symbolic aspect to that, which is that we're supporting somebody who's encountered harm on our watch. But there's also a proactive part of that, which is the coverage also covers holding the harasser accountable, including and up to firing that person and covering any lawsuit that they might bring for defamation or wrongful termination.
Do these policies, these first person policies, cover training too? If there's harassment and it's found to be verifiable, that it would cover the expense of maybe bringing in someone to train the employees?
Yeah, it could. I think that the problem with the existing systems and the reason that we need to look deep in, as Kit likes to say, the plumbing in the basement, is the known solutions by themselves are not working, right? I think most corporates at this point have some kind of annual training or biannual training on workplace harassment. They have all sorts of things, hotlines, ombudsmen, all sorts of efforts to deter. But alone, these are not effective. We are finding that so the importance of the Me Too movement cannot be overstated. But the response, the corporate response to that movement has been underwhelming because it's more of the same. We are suggesting a systemic change to something that is generally unknown and inaccessible, but it's a system, which means we're not looking to go out there and change hearts and minds and have people address their own, I don't know, internal Jiminy Cricket about how to react to these things. We're trying to say, don't make it a choice. You might have a wonderful HR team that always makes the decision that's right for your employees. Or you might hire by mistake a harasser on your HR team. It's an unknown. So, what we need to do is install systems like this, wherein you do an investigation and the outcome of that investigation matters more than who plays golf with members of your board.
And I wanted to make sure that it was clear when you guys said investigation is done, that's an internal investigation. So the report that you were referencing was a report internally, presumably to HR and not to the EEOC or the state equivalent agency.
Correct.
Yeah, it could be an internal investigation or it could be an investigation that you pay a third party to conduct. But yes, it is the company's investigation.
Okay. And what if an employee decides to skip that whole internal process and file a complaint directly with a government entity?
Generally, that is the case now. If someone decides to complain and if they have the wherewithal to learn the system, because I don't know about you, but in my childhood, I was not taught about the EEOC. So, in terms of being a worker specifically in the US, if you know about that whole system and you've done your research and you want to put all of your time and energy toward filing a claim with the EEOC, despite the overwhelming likelihood of retaliation, then yes, people can do that. I think the challenges now are that the reporting systems don't seem to result in any level of justice. And so, writ whole, people don't trust HR. HR folks are just in the tightest vice at this point, right? They are stuck between the employer who wants one thing and the employee for whom they are supposed to be benefiting. So, HR is in a mire. They are accused of not working for employees, but for the employer. This is exactly the type of system that forces them into that space of unwellness. And if folks do decide to report, they are among 6 to 13% of people who ever make a formal complaint. 7 to 94% of people who experience workplace harassment never make a formal complaint.
Yeah.
So
So
that's the issue.
so to trigger the endorsement, to trigger this possibility of reimbursing for expenses to make the harassment victim whole, what is the mechanism that needs to happen to trigger it? It's not going to the government. It sounds like it's not going to the government. But you just said, Lauren, that people don't go to HR because they feel like HR is not helpful, and very few people make a report to begin with. So I guess I'm curious to hear what is the system that needs to be put in place? And are you guys the ones that help put that system in place at the workplace?
So when we do change the words of the policy itself with the endorsement, there is a necessary rollout of awareness across certain levels of an employer who chooses the endorsement. That would include, for sure, HR. HR policies will change in regards to employee on employee harassment or discrimination. Same thing with the legal department, and very importantly, managerial staff. So folks who are often motivated to assuage concerns before they get to HR, and HR folks who are often told managing this ahead of it getting outside or into legal is the best way to go. That needs to be eradicated. Any concerns need to be able to be reported as soon as humanly possible. And the reason for that is the system we're changing, it has a lot to do with the goal of EPL. Right now, EPL says the real risk is claims, which is a wild and incorrect assumption. The real risk is harassment or discrimination in your workplace. So, what we're trying to do is empower communication early when these problems are small and inexpensive. The
Mhm.
idea is that with an appropriate rollout, after the endorsement has become part of a company's systems, you're able to catch these things early. You're able to have insurance cover the costs without busting through a cap. And you're able to set an example for the other coworkers within that company. I saw that when my coworker reported, they were taken care of, and the company took responsible steps in regards to the harasser. That creates a culture of early reporting, and that is always going to be the goal because that leads to safe workplaces.
Yeah. So what is exactly your role, your company's role? And remind us again, your company, Third to First, it's a for-profit or not-for-profit organization?
This is entirely my fault. We structured as a for-profit in hopes that we would have an easier time connecting with companies and with insurers and really being taken seriously. I think that a lot of nonprofits doing really outstanding work are thought of in a certain light when it comes to actually making real change. And call that a chip on my shoulder from many years of volunteering and helping manage nonprofits. But
Mhm.
I think that's a reality that we're trying to deal with. And in terms of services, everything, soup to nuts. So the idea is that we help folks with the wording of their policy. We can help folks negotiate that policy in with their broker. We can assist their broker in negotiation with their insurer. We can also help insurers change their baseline offering, something we are still looking to do because that would be the fastest way to scale this good. So those are all things we offer, but especially and including the rollout on a per company basis. That becomes very important because that is not only the thing that creates a better and more wellness infused workplace, but it creates significant cost savings for the company.
And that leads to my next question. So an employer would have to come to you to say, "Hey, we want to include this endorsement on our EPL policy. We want you guys to help roll it out so that employees are aware of it and we have the system in place." How what kinds of employers have you seen wanting to do this? What does it take for them to realize, "Oh, we need to make this change"? I'm curious to hear who is reaching out to you. What's your avatar?
Kate, do you want to cover this one? I know you
No, you
are
go
not quite
right
sure.
ahead.
Oh, okay. Yeah, it's interesting. It's the extremes. On the one hand, there are companies that have had these problems. So there are companies who are coming up against the limits of their EPLI policy because they need to use that coverage. And they're realizing that the current system just doesn't work. It doesn't stop harassment or discrimination. They end up losing full toxic pockets within their workplace because everyone leaves. There's a lot of attrition when these things aren't handled well and when bad actors end up being unintentionally protected. So, dissatisfaction with the current system is one big reason that folks like chatting with us. And the other is being an outstanding, outspoken company for workplace safety, for women's rights in the workplace, because while this does and can impact every worker within a workspace, it does have an outsized effect on women in the workplace, in particular, women of color in the workplace. So any organization that takes a stand on behalf of women in the workplace is a great candidate, not because they stand to have a different setup with their insurer, but because it's something they can talk about when they're recruiting new talent.
This is a fantastic product idea. No wonder you won a Fast Company award for it. It really is. It seems it's one of those things that seems like, why didn't I think of that? Or it seems so obvious. And it should have been thought of a long time ago. And you guys are making it come to fruition. If people wanted to learn more about your work and the opportunities, that if they're an employer or HR person, or even let me just put a plug in for the wellness community, since that is my primary audience. This would be a great component of a holistic, comprehensive workplace wellness program. You could add in this idea of changing the EPL insurance to include this endorsement so that harassment is covered and addressing the actual toxicity and harm that's being done to the employees. Because, as I've said in many previous Wellness Lab podcast episodes, if we got to get away from blaming the victim and telling them what they need to do to change their lifestyle, to creating an environment that is supportive to people reaching their full potential. This would be one of those things. So for those wellness companies out there looking to partner with you guys, I think that would be a natural thing to do and a great benefit to both clients and the vendors. So how can they learn more and get in touch with you guys?
All of our information is on our website, thirdtofirst.com. Easy enough. And you can reach us there. You can learn more about the work itself. You can learn all about the data that has gone into compiling our approach. Our research is linked there, and there are resources there for folks who are looking for resources as well. But generally speaking, yeah, we're very responsive and thrilled to chat with people who want to make the workplace better.
Thank you. Any last words from you, Kit?
Nope, that's Lauren summed it up perfectly.
Great. Thank you guys so much for being on the podcast, for sharing your wealth of knowledge and your passion. And I really do hope that the wellness community hears this and considers including this concept in its program offerings, both the employers who implement the programs and the individuals who are hired to implement the program. So thank you so much.
Thank you,
For having
Barbara.
us.